Well, good morning, everybody. My clock shows 9 a.m., so we'll get this webinar kicked off promptly. By way of introduction, my name is Jason Castor, and I'm the Chief Business Development Officer for the law firm of Parsons, Behle, and Latimer. And we'd like to thank all of you for carving out a few minutes of your moment to joining us for today's presentation. Before we get underway with the formal presentation, I wanted to just briefly touch base on the format of today's webinar and touch on some housekeeping items. All of your lines currently are muted. We will lift that towards the end of the presentation today, or at the conclusion of today's presentation, because we want to open up for Q&A and provide you with the opportunity to ask our presenter, Kevin West, my colleague and attorney at Parsons, Behle, and Latimer, questions at the end of today's webinar. So again, all lines will be opened up at the end of the call so you can direct your questions. If there are urgent questions, you can certainly shoot those to me via chat, but we will have time at the conclusion of today's presentation to address your questions. Also, this webinar is being recorded, and the slides that you will see that complement Kevin's presentation today will be shared with you. We will send out an email tomorrow with a link to the webinar recording for you or colleagues of yours that perhaps missed today's webinar to watch at a future date, and you can also review Kevin's slides. And with that, I would like to now turn the time over to Steve Brown. Steve is the Director of Professional Liability Claims from Corizon Health. Steve, welcome. It's nice to have you with us this morning. Thanks for this opportunity. And I'll turn the time to you for a few minutes for your opening remarks. And Steve, I've just unmuted your line. You are live.
Okay. Thank you, Jason. Yeah, as Jason said, I'm Steve Brown. Most of you folks know me. I head up the PL Claim Department here at Corizon. And I want to thank all of you for taking the time this morning to be with us. I'm calling you from my home. I guess I'm going to have to get used to this. I miss being around the folks in my department and other people there at Corizon. But and I kind of think my wife might like me to go back to the office, but I'm kind of getting used to it. So I might be around here for a while. But anyway, our topic today is on Medicare. Let me give you a little background. Our speaker is Kevin West. Some of you have worked with Kevin on some of our Medicare cases. But I've worked with Kevin for over 30 years, and he does exactly what I expect from an attorney. That is, treat every case like it's your first case. And he's done that ever since I've known him. But to give you a little background on how he got involved in Medicare, because that is a little bit unusual for a medical malpractice defense attorney. But about 20 years ago or so, I was with another company that wrote malpractice coverage for podiatrists. And podiatrists, a lot of their patient base is a little bit older, a lot of folks on Medicare. So Medicare decided to take a look at podiatrists around the country for fraud, Medicare fraud. And so the company that I was with contracted with another insurance carrier to fund a program that would pay defense costs, not fines or anything like that, but defense costs up to, I think it was $25,000. And so it was their dollars, so they controlled the attorney that we would use. And so they brought an attorney who did have expertise in Medicare. I certainly didn't know anybody at the time that had that kind of knowledge. But this individual, even though he knew Medicare inside and out, didn't have the work ethic that I expected from myself and from all of our attorneys and the members of my department. He was slipping in that area. So it took me a while, but those of you that know me know that I don't give up, and I keep trying. And so it took a while, but I finally convinced that other carrier to give us the authority to bring in another attorney to replace this person. Well, I just mentioned I didn't know anybody, but I did get in touch with Kevin West. He's out of Idaho. And for those of you who have ever been to Idaho, there's not much there. Not very many people. So if you don't have many people, you're not going to have many malpractice cases. And Kevin was literally one of our best attorneys on these malpractice cases, but I just couldn't get him a lot of business. He deserved the business, but I just couldn't get it to him because we just didn't have a lot of claims in Idaho. So I called him, and even though he didn't have a background at that time, I knew he was very intelligent and had that work ethic I was looking for. So right away he said yes. And he started learning, and he's kept learning. And he's still, part of his practice today is involved in Medicare. And as all of you know, here at Corizon, when we started our department back in '07, one of the first things I did was announce that any case involving Medicare, I wanted Kevin West brought in. If we ever get back to the days of in-person mediations, we don't need Kevin to attend the mediations, but I want him to be available by telephone. I've been to mediations before where myself included, the attorneys there, the mediator, no one really had an expertise in Medicare, but we had Kevin on the line, and he educated all of us. So it's essential. It's imperative. No exception that with Medicare cases we bring Kevin on board. Just to tell you how serious this is about Medicare, from my memory from those early days with the other carrier, I still recall Medicare sending in FBI agents unannounced to our doctor's office with a court order requesting the original records, not copies, the original records. And these were FBI agents. Now, they never drew their weapons, but they were armed because some of our physicians and their staff saw the pistols, but they never drew their arms, anything like that. Nothing like that ever happened. But unannounced, FBI agents would come in, get those original records. We'd have to call Kevin. Kevin would talk to the officers, the FBI agents, and try to get some time where our people could at least make copies of the records. Because we did learn that once Medicare was finished with their audits, a lot of times they weren't as careful with those original records as we would like. But that's the background. Kevin knows what he's talking about, and I take Medicare very, very serious. So with that, I'm going to turn it over to Kevin West to bring us up to speed on what's going on in Medicare and to educate us. Take it away, Kevin.
All right, thank you. Jason, are you hearing me okay? Give me a thumbs up. All right, great. Well, hi, everybody. It's good to talk with you. I wish I could say I could see you. It's good to see you, but I at least I can at this point. As Steve said, I'm here in Boise, Idaho, a remote place. We do have running water and electricity. We got that recently. And we actually have these newfangled computers where we can do these webinars. So I use this technology all the time, but I'm not loving it. I'd rather be in person with all of you and enjoy seeing you again. So hopefully all of you got the handouts that I sent to Steve and Steve distributed to all of you. We'll mention some of those today as we go along. So as you saw from the title, this is a Medicare secondary payer update. It's not intended to be Medicare 101. I'm assuming people have some basic level of understanding about the Medicare Secondary Payer Act, so I'm not going to treat this like we're starting from scratch, but I'll try and give a little perspective and try and point out a few basics as we go along, and save up or write down questions. We'll talk about those at the end, or send them on the chat line to Jason and he can get them to me either way. So the basic concept of the Medicare Secondary Payer Act, which by the way has been around for decades, but the basic concept is that when Medicare pays medical expenses that are caused by a third party, Medicare will go ahead and pay those medical expenses initially, but they pay it conditionally. And they pay it with the stipulation that they are, in fact, a secondary payer and that their liability and responsibility is not primary on that obligation, and that the third party is, in fact, responsible ultimately to pay those medical expenses. And Medicare gets what is called a priority right of recovery. Technically, it's not a lien, but I'm going to refer to it as a lien just because it's easier. But the legal term is a priority right of recovery to come back in and recover what they paid conditionally at the outset. So that's the basic concept of the Medicare Secondary Payer Act, is that Medicare is paying conditionally. They have a super lien or priority right of recovery to come back in and recover what they paid that was caused by a third party. So just a little historical perspective, which I think is helpful to understand where we are today. The Medicare Secondary Payer Act's been around for decades, as I mentioned before. I think it was enacted back in the 70s. And really no one paid a lot of attention to it because there wasn't a lot of teeth in the law. But that changed in 2007 when the law, the MIMSIA law was enacted, and what it did was put a $1,000 per day penalty on insurance companies or tortfeasors if they failed to report settlements that were made to, if they failed to report settlements to Medicare. And so that suddenly got everyone's attention, $1,000 a day, obviously. And so it really was at that point that, as Steve mentioned, we started talking about this, looking at this issue. And when the law was changed and suddenly we had to report these settlements and suddenly start having to address the Medicare lien, there was just a flood of anxiety and concern about the issue of how do you deal with future medical expenses that a claimant may have. And the market was flooded with companies marketing Medicare, I should say Medicare, not Medicaid, sorry, Medicare Set-Asides. And, you know, those set-asides had been done for many years in the workers' comp arena, but in liability they had not been done. But suddenly everyone and their mother was saying that you had to do a set-aside on these liability cases. There was a great deal of liability, or excuse me, uncertainty about, you know, how to handle that. Okay, so Jason, next slide. In that environment, Congress passed what was called the SMART Act of 2012. It helped somewhat in that it softened this $1,000 a day penalty language from being penalty that shall be imposed to one that may be imposed. And it also said that it might not be $1,000 a day, but it could be up to $1,000 a day. And there were some great changes proposed in this law, and Congress said that CMS would propound regulations, and we waited and waited, and those regulations that were proposed were never finalized, and they were ultimately withdrawn in 2014. And I think the last time I did training with Corizon defense attorneys was back in this time frame of 2012 or 13, where we had this new law, we had these proposed regulations. I gave a seminar at that time, and we were hopeful that things were going to be clarified and resolved. Well, they weren't. And those proposed regulations were withdrawn. We don't have them, and we have no further guidance, really, than what we had from the very early days. Continuing on in the history, in 2017, Congress said, you know, the Medicare Secondary Payer Act is for Medicare, the Medicare program. We want to also have it apply to the Medicaid program, which is partially funded by the federal government and by state governments. So this gave state Medicaid agencies the same priority right of recovery that Medicare has. So now if we're dealing with a claimant who is on Medicare or Medicaid, we need to be aware of this super lien priority. And Medicaid has become much more significant in the past 5 to 8 years because, as you all know, Medicaid expansion has dramatically increased the number of people who are now on Medicaid. So we should be aware of that. Next slide. Coming more currently, CMS came out with some regulations, proposed regulations on this $1,000 a day reporting fine. These proposed regulations address the when and how that will be imposed. Once again, we're waiting for those regulations to be finalized. That may happen this year. And I was at a conference recently with many experts on this particular subject, and the rumor at that conference was that in the fall of this year, there is finally going to be additional guidance from CMS on the issue of set-asides. And I'm not holding my breath about that, but we'll see if it happens. So, you know, the bottom line is, you know, we handle past expenses in a certain way, we handle future in a certain way, and everyone's been speculating about set-asides now for 15 years. Nothing has really happened, and the general practices I'll talk about later is really that they are not required, but certain things do have to happen. All right. Okay, there we are. Thanks, Jason. All right, so that's a little bit of history as far as where we are today. The current threshold, and this is really more a Corizon issue than a defense counsel issue, but the current threshold for reporting settlements to CMS that involve a Medicare beneficiary is $750. It initially was much higher. It's gradually come down to this threshold. So really, about any settlement or verdict is going to be reportable. There are, in small cases, a couple of options that hopefully everyone should be aware of, and those are for settlements that are less than $5,000 or less than $25,000. So let's talk about those for a moment. So in the area of settlements of less than $5,000, and occasionally we still see those, not often, but we still see them. So those are called the fixed percentage option settlements. And if it's $5,000 or less, what you can do is send in a form to CMS, and if the settlement, for example, is $4,000, you send in $1,000 to Medicare, 25% of the gross settlement, and that resolves the Medicare lien. Medicare lien could be $100,000, but this option will satisfy the lien as long as the amount of the settlement is $5,000 or less, and you've submitted 25%. In the handouts that Steve sent out, there is a form that can be used for these types of settlements. The other one is the settlements of $25,000 or less, and this is called the self-calculated conditional payment option. And what happens there, and again, you have a form that Steve sent out yesterday for this particular option. And as you see on that form, there's a number of things you fill out. For CMS, you submit documentation of the amount of the medical lien, and you basically propose to CMS that you want to settle the case, and here's the lien amount, and you are to do you do certifications on this form. So it is something that you've got to certify under penalty of perjury. But in those situations, Medicare will review the documentation. If they approve it, then the settlement is resolved at that point in time. One thing I would point out is even for settlements less than $5,000, you could still use this option. And for example, say you, well, excuse me, let's say you have, I said that in reverse actually. Say you have a settlement of $5,000 or less, but the lien is only $500. So it would not make sense to send in $1,250 to Medicare to satisfy that lien if it's only $500. So you could use the $25,000 option, send in the documentation showing the medical expenses are only $500, and go that route and resolve the case. So anyway, for small cases, these are helpful tools that may not be used often, but it's good to know that they are there. All right, next slide. As to Medicare set-asides, again, these are not required. And let me clarify that in settling cases involving Medicare beneficiaries, we always have to look at past medical expenses and future medical expenses very differently. With past medical expenses, we're going to talk about the best practices on how to resolve those with Medicare. And that's really developed in a very clear way. We have a pretty good method of how we deal with those. For future medical expenses, this is where we have the whole issue of set-asides. Do we do them? Do we not do them? If so, how? So we'll talk about that. But the law, as of right now, is that they are not required, but CMS, as we'll hear throughout this hour, does recommend that we do something to protect their interests. That does not have to necessarily be a set-aside. It could be an annuity. It could be documentation that the plaintiff and counsel have made provisions to protect as to the future expenses. It can be done in a number of ways other than a set-aside, but we need to be able to demonstrate that Medicare's interests have been accounted for and that we have taken reasonable steps to satisfy or protect that interest. All right, next slide, Jason. So there, over the years, have been some internal CMS memos. These do not have the force of law, but it gives you an idea, at least, of the thinking at CMS some years ago. This Stall Cup memo that came out in 2011, again, it reiterates that the law does not require a set-aside, but it requires that Medicare trust funds be protected. And you see there, if defense counsel or the insurer determine that the settlement is going to include future medicals, they should document that the settlement does fund the future medicals, which obligates them to report it to Medicare through the mandatory reporting and obligates them to protect the Medicare trust fund. So that's the basic concept, protecting the Medicare interests. Then there's the Benson memo. This sort of mentions another technique of how to address future medical expenses, and that is to go to the plaintiff, the Medicare beneficiary's treating doctor, and get a certification from them that treatment has ended and that they do not anticipate future medical expenses. Now, many doctors are not going to be willing to do that. Many plaintiff's attorney may not be willing to make that representation or get that documentation at the time of settlement, but we have seen that happen in certain circumstances. So if we get a certification from the treating doctor saying that, there is no need really to address future medicals any further, and that issue is resolved. All right, next slide. Since we started doing all of this back in 2007, 2008, we didn't pay a whole lot of attention to Medicare Advantage, and the world has changed in that regard. And there was a question for a while: do Medicare Advantage plans, which are completely separate and apart from traditional Medicare, do those plans have a priority right of recovery like traditional Medicare does? And the line of cases that has come down is now pretty clearly established that, in fact, Medicare Advantage plans can enforce liens essentially to the same extent as traditional Medicare. And you see the citation there. Next slide. These are just some places you can go for the Medicare Secondary Payer Act statute there in 42 U.S. Code, 42 CFR Section 411, and also Section 422 or are places you can go to find the regs that we currently have. As far as, some case law, there have been a lot of cases that have come down. I'm not going to do a big review of them right now because I'm staying more with nuts and bolts and practicalities right now. But there is this Aronki case that, again, confirmed that CMS has not required, or Congress has not required, set-asides. CMS does not have to, make a ruling at that point in time. And the court said, there may be a day when CMS requires creation of set-asides in personal injury cases, but that day has not arrived. And then likewise, in this 2017 case in federal court in New Mexico, saying the same thing. There's no law or regulation currently in place that requires CMS to decide whether plaintiff must create a Medicare set-aside for personal injury settlements. But this is, the language that troubles people. However, CMS provides no other procedure by which to determine the adequacy of protecting Medicare's interest for future medical needs and or expenses in conjunction with the settlement of third-party claims. So everyone's recognizing there's this tension. The law doesn't require the set-aside, but yet we can't ignore Medicare's interest completely. And in the settlement process, we need to protect their interests. All right. Another thing in this conference I went to some time ago with really a nationwide group of experts and attorneys dealing with the issue of the Medicare Secondary Payer Act, it appears there's quite a cottage industry that has arisen where these recovery companies are getting assignments usually from Medicare Advantage plans, frankly, and taking those assignments and going out and suing either tortfeasors or their insurers in order to collect on the Medicare lien. Right now, there's close to 100 cases nationwide. They've tried to certify classes. That hasn't been successful, but the individual cases have been allowed to go forward up to this point in time. So those are some recent developments. So let's talk a little bit about some best practices in handling cases where we have a Medicare beneficiary or a potential Medicare beneficiary. And the first thing, which seems so basic, but I just don't see sometimes defense counsel doing this, and that is to get as much information as possible in initial discovery about the plaintiff's status and to find out, are they in fact a Medicare beneficiary? If not, is there a likelihood that they may be in the very near future? We've got to know that. My standard set of interrogatories and requests for production that I send out at the beginning of every case asks for that information. And it's a best practice to actually ask to get a copy of their Medicare card front and back and have them send that to you. I'm dealing with another insurance company right now where I've been asked to look at settlement documentation, and the first question I asked of counsel and the insurance adjuster was, is this person a Medicare beneficiary? Because you have that language in your release here, and they did not know. They had not gotten discovery, they had not gotten proof one way or the other about whether this plaintiff was in fact a Medicare beneficiary. But yet they're in the process of documenting a settlement of the case. So we just cannot ever allow that to happen. We should be knowing from the very beginning of the lawsuit if we're dealing with a Medicare beneficiary. And if we are, we've got to take certain steps. And one of those steps is to let plaintiff's counsel know that you know, we've got a Medicare beneficiary here, and we cannot even entertain settlement discussions or go to mediation unless we have information about this person's status, and without getting what's called a conditional payment letter, which comes from traditional Medicare, or if we're dealing with Medicare Advantage, they will send out just a basic lien letter specifying the medical expenses. So we need to make very clear to plaintiff's counsel, we cannot proceed without getting that information. Now, be aware that the conditional payment letter only relates to past medical expenses. It doesn't get us off the hook on future expenses, and we'll talk about those for a moment. So sophisticated plaintiff attorneys may know about this, but my experience is most plaintiffs do not. They don't know about the Medicare Secondary Payer Act. They don't know about Medicare liens. They don't know how to report a claim or how to get information. So we need to help them out and have them become aware that they can go to cms.gov, and if they click around, they will get lots of information about what's called the Medicare Secondary Payer Recovery Portal. This is new from when I started doing this kind of work. It's only been around for a couple of years, but it's a portal that allows either the claimant or their counsel, preferably their counsel, to get information about the Medicare lien and the details of that. Plaintiff's counsel can go to that portal. They can request a conditional payment letter. They can request lien information, and it's a valuable tool. There's a number you see on the screen there. There's an address. But we should be giving this information to plaintiff's counsel, because if they don't cooperate with us in getting this information, it's going to be impossible to settle the case, or at least impossible to settle it in an appropriate way. Let me tell you two other tools besides the use of this portal, and let's stay back on that prior slide, Jason, for just a moment. Two other tools. One is that Medicare beneficiaries can go to a website called mymedicare.gov, and they can go there without counsel, and they can ask for information regarding their medical expenses. So sometimes they can actually get the information more quickly by going to mymedicare.gov than by going to this portal. So that's another option you can suggest to counsel. Sometimes when we've gotten a conditional payment letter and we're getting ready for a mediation, you can actually have the plaintiff go to mymedicare.gov and actually get the most up-to-date lien information in that way. Another thing you can do is ask for plaintiff and plaintiff's counsel to sign a consent form that actually allows you to directly go to Medicare and get information. And I've given you, in your handout materials, I've given you a form. And you could send that form to opposing counsel in discovery, ask them to sign it, and that would actually give you as defense attorney the ability to go to Medicare and get some of this information. So anyway, those are three different ways of approaching Medicare to get lien information regarding past medical expenses. Okay, Jason, I'm ready to go. Another tool that I've recommended and used in the past is to have a letter addressed to plaintiff's counsel. And again, in your handout materials, you'll see that letter. It's a 3-page letter. This slide says 30 days before mediation. I would suggest 60 to 90, actually, because if you've got a plaintiff attorney who has absolutely no clue about Medicare, it's going to take longer than 30 days to get the lien information that we need to get. So I would get that letter out soon, and that letter really lays out the Medicare lien process, and it it establishes some expectations about what you are going to be needing to have happen in order to settle the case. So again, it's a tool you can use if you want to. You can modify it, but I do recommend it. Okay. So options for satisfying a Medicare lien. We're talking about past medical expenses here, not future. So really over the years, I've seen 4 different options. I would say none of these are 100% satisfactory, but they each have their upside and their downside. But the fundamental problem that we have is that CMS will not issue a final demand with the final medical expense amount until after the case is settled or there is a verdict. Their system just won't allow that. So we are always going into settlement and mediation with some level of uncertainty as to the exact amount of Medicare's lien. We may have done the right steps and gotten the conditional payment letter, and we may have an idea as to the lien amount, but we will not know the final dollar amount to the penny until afterwards. So dealing with that tension is why these 4 options you see on the screen have come about. So one option is with plaintiff's counsel that we trust is to say, okay, look, we're going to have you hold the settlement money in your trust account until that final demand is issued from Medicare, and then our settlement papers will, allow for the payment of the lien and the balance to go to the plaintiff at that point in time. So that's one option. The other is for us as defense counsel to hold back some of the money in escrow or in a trust account. We can disperse some part of the settlement, but hold back some part in escrow until until the final amount is determined. Another option is to, again, with money being held in one account or the other, is to cut separate checks to CMS and to the claimant. Sometimes for timing reasons that may be difficult. The last option, which we used to do more of but now has become discouraged, and CMS is really saying don't do it, was to put Medicare and the claimant as joint payees on the settlement check. So that's one I do not recommend doing at this point in time, and there's a lot of problems. But these are the options that attorneys throughout the country have used in different matters. I saw a chat comment come in from somebody to the effect that we may be ordered by the court to do something even different than one of these 4 options. And obviously that's a problem, and we have to follow court orders, but we also need to do our best to educate judges on this tension that exists in getting that final demand amount. All right. Settlement documentation. This is where I'm often getting involved. Sometimes people are good enough to talk to me before the mediation, but it seems like most often I'm getting brought in at the point of, the case is in mediation or we're trying to settle it, and the issue is how do we document things. So as to the past medical expenses, clearly we need to spell out who is going to reimburse Medicare and how and when that is going to happen. And the prior slide that had the 4 options, will be something we'll want to talk about. In your handout materials is the standard release form that I have used for quite a number of years. I've provided it to Verizon claims people, and probably many of you have seen this. I'm not saying it's the final, perfect, best release agreement, but it's one that certainly does address many of the things I'm talking to you about here today. So another thing we need to look at is this issue of getting a waiver of the plaintiff's statutory cause of action under the Medicare Secondary Payer Act. So let me explain that a little bit here. When we settle a case with a Medicare beneficiary and there are future medical expenses that are at issue, after the case settles and the plaintiff goes and continues treating with doctors for those ongoing future medical conditions, at that point in time, Medicare, all it can do to enforce its lien is to deny benefits or deny payment to the plaintiff. Medicare really does not have the ability to go after the defendant or the defendant's insurance company for the future expenses after the settlement, because those expenses have not yet been incurred, and they're certainly not going to try and go after the insurer every time there's a doctor visit. So Medicare has a problem. They really can't go after the tortfeasor, the settling defendant. Once the case is settled, they can't go after them for the future medical expenses. So Medicare's only option is to really say to the plaintiff, look, we've already paid for that in your settlement, and therefore you should be using those monies for that ongoing expenses. The plaintiff at that point could turn around and sue the tortfeasor and the insurance company with this private cause of action under the Secondary Payer Act. Why that makes sense that they have that cause of action is not clear to me, but they do. And so that means that when we settle these cases, we need to get an express waiver of that cause of action under the Medicare Secondary Payer Act. And that's one of the provisions in the release agreement that we provided to you. Another issue is addressing what I call relatedness issues in the demand letter that comes from CMS. And let me say here that there are actually sort of two junctures at which you can contest the past medical expenses that a claimant has. As we mentioned before we go to mediation, we want to see this conditional payment letter from Medicare listing all of the medical expenses that they deem to be related to the wrongdoing involved in the lawsuit. Oftentimes, that listing will have medical expenses that are not related to the incident in question. And it's very important at that stage, at the stage of getting the conditional payment letter, to have plaintiff's counsel write back to Medicare, take that same list and interlineate the items that are not related and make sure that Medicare is aware. And that's to the benefit of the plaintiff, and that's to the benefit of us is on the defense side that happens at that point. Once the case settles and Medicare issues a final demand letter, there is a potential that there will still be unrelated medical expenses at that point. And those unrelated expenses can still be contested, but at that point, as a defendant, we are probably not going to want to be involved in that process, and it's going to have to be the plaintiff attorney, if he chooses to appeal and try and address that. But from our standpoint as defense attorneys, we want that addressed well before settlement, well before we get the final demand letter. Okay, next slide. And this leads to the next issue. When Corizon or the plaintiff attorney reports a case or a settlement to CMS, they are required to specify the injuries and the diagnoses that are involved, and that they are to use codes called Icd-10 codes to very precisely and specifically identify the injuries and diagnoses that are at issue. Medicare uses those Icd-10 codes to determine in their data bank what medical expenses are related, and they will pull all medical expenses that are tied to that Icd-10 code. The problem is if the injury or diagnosis is identified too broadly with the Icd-10 code, and if the settlement language sort of has the kitchen sink of every injury or anything that's ever happened to the plaintiff, we can get conditional payment letters and lien letters from Medicare that are far too broad and that include many unrelated expenses. So we need to work with Corizon in identifying the precise injury diagnosis that are covered by the Icd-10 codes and make sure that is properly reported to CMS. The settlement documentation should disclose to the plaintiff the rights they have to procure, to appeal the unrelated medical expenses. They have a right with their attorney to get recovery of what are called procurement costs for protecting Medicare's lien. Those things should be disclosed in the settlement documentation. There should be a cooperation clause requiring plaintiff to give us post-settlement updates, in particular documentation from CMS showing that the Medicare lien has in fact been satisfied. And really that's the ultimate goal, is we want to know from CMS the plaintiff and their attorney paid that lien off, and that we as the court fees or insurance company are no longer on the hook for that. Okay. In some cases, especially catastrophic cases where there may be excess exposure, we want our settlement documentation to state that liability is disputed, that benefits under the policy have been, in fact, exhausted in those cases. We want our settlement agreement to specify who gets what's called salvage. So, say at the time of the settlement, the belief is that the past medical expenses are $50,000, but through the process of appealing or determining what are unrelated expenses, it actually turns out that the expenses are really $40,000. So who gets the $10,000? And really, in most cases, we're all assuming that that will go to the plaintiff attorney, and probably that makes sense in most situations. But we do want to address that potential issue when it's appropriate. Okay, going to the next slide. In certain states, this practice of holding a portion of the settlement money back until we get the final lien amount, that can sometimes be a violation of states' unfair claims practices laws. So we want to be aware of that and navigate around that problem by certainly addressing it in our settlement agreement and getting a waiver from the claimant to allow that kind of delay. Now, in some cases where there are going to be extensive future medical expenses, as we talked about earlier, we need to demonstrate that we have taken Medicare's interests into account in some fashion. And there's a number of ways we can do that. One is to, in fact, go out and hire a company and do a formal Medicare set-aside. And that's going to require the agreement of opposing counsel. some people go and get a life care plan. It's really the same type of thing. And that documentation should be attached to any settlement agreement, along with language stating that the plaintiff is aware and agrees to this set aside, that money is going to be allocated for the future medical expenses, and that they understand fully that Medicare in the future is not going to pay claims for those particular expenses. If we have gotten a determination from a court in which fault is allocated among the parties, we will want to attach that to any kind of documentation that goes to CMS, so that CMS won't be looking to us for 100% recovery of the bill if in fact we're only responsible for 50 or 70%. Right. Going to the next slide. So those are the kind of the documentation issues. Let me talk about some sort of challenging situations or complexities that we have also been encountering. So one involves Medicare Advantage plans. Many people are not aware, don't even really understand what Medicare Advantage is. There's traditional Medicare, that is Part A and Part B, and then there's Medicare, which is Part C. And these Medicare Advantage plans are operated by private insurance companies. They have to follow certain CMS standards, but they are in fact on a totally different system. They do things differently than traditional Medicare. They don't have the same database as traditional Medicare, look at all the expenses. And so it's a problem sometimes dealing with these Medicare Advantage plans, but they become hugely popular. About a third of all Medicare beneficiaries are now on Medicare Advantage, so we've got to be aware of them. Sometimes, we will go to Medicare and we'll ask for a conditional payment letter, and we'll get a letter back from Medicare saying we have zero record of any medical expenses for this person, and sometimes people have relied on those letters, not realizing that the person was in fact on Medicare Advantage, which is not part of the traditional Medicare database. So we have to be very careful in seeking information from all the appropriate sources. The other thing that makes things very difficult is people can change their plans from year to year. So at the time of injury, someone may have been on traditional Medicare, but immediately after they switch to Medicare Advantage, or vice versa. So it can be more difficult to get a complete summary of medical expenses. So take an example. Say we have a case filed in 2020 involving an incident in 2018. Suppose that the claimant was on Medicare Advantage at the time of the injury, and they incurred medical expenses under Medicare Advantage during the year 2018. Then in 2019, they switched to traditional Medicare. They have no expenses during that particular year. And then in 2020, they continue on with traditional Medicare. If we go to traditional Medicare and ask them for a conditional payment letter, we're going to be told zero. And we're going to have a false sense of security that, hey, there's no Medicare lien here, when in fact there could be a substantial lien with the Medicare Advantage plan that they have every right to recover. So that goes back to the initial discovery request to the plaintiff. We have to be wording that so that we are not asking only for traditional Medicare, but we are also asking about Medicare Advantage, and so that we are also asking for Medicaid, because all of those three options are going to have a priority right of recovery. Going to the next slide, Jason. So this is just, again, the point I was making a moment ago about getting discovery out. We all need to understand the difference, at least the basic differences between traditional Medicare and Medicare Advantage plan coverages, because Medicare Advantage has the leeway to go above and beyond traditional Medicare in what they cover, which is part of the reason these plans are so popular. We should be getting the Medicare card or the Medicare Advantage card from people. Just like when you go to the doctor's office, many doctors will say, when we see your insurance card, they photocopy it. We should be asking for that in discovery. And again, we should not be assuming that just because traditional Medicare does not have any bills that they are not in the Medicare Advantage plan. We should not assume that once we get a conditional payment letter listing expenses that the person is not still treating, because in fact they may still be doing that. Okay, next slide. I mentioned earlier that there is a process for challenging a lien amount. The most effective time to do that is at the time the plaintiff attorney gets the conditional payment letter and hopefully shares that with us. We can do it without any formal legal proceedings. All that is required is that the list be sent back to CMS with interlineation showing the unrelated items. That's the best time to do it. Once the lien is finalized and that final demand is sent, there is a formal appeals process that can be used to appeal the amount of the lien. The problem is that's going to take a long time to do it. It could take up to a year or two, in fact, to fully appeal these medical expenses. So my opinion is that, you know, if plaintiff's counsel wants to go through that appeals process, they can do so, and we should allow them to do it. But it's rarely ever going to make sense for us to get involved in that process. Plaintiff's counsel should know that Medicare pays what are called procurement costs. So Medicare is saying, look, in return for you, plaintiff attorney, helping us recover our lien, we're going to give you a portion of that as procurement costs, and there's a formula for how that is calculated. But we should let claimant's counsel know that, and we can use that as leverage as part of the settlement process. Okay, next slide. We mentioned this earlier about be careful with over-reporting on Icd-10 codes. We will just get conditional payment letters with lots of unrelated claims. And you should be aware, this is mind-boggling, there are actually 69,000 Icd-10 codes. I have an Icd-10 book. It's about that thick. And some of those codes are not even reimbursable. They're for reporting purposes, but they're not reimbursable codes. Okay, next slide. Another thing to be aware of, and why we want to carefully document how future medical expenses are going to be handled, there have been some court cases come down where settlements have been nullified because the court said, you guys didn't address this. It's a key term of the settlement, and the court has thrown the agreement out because of a failure to address that particular issue. Okay, next slide. So returning again really to this issue of Medicare Set-Asides, we know we don't have to do them legally, but we know we have to protect Medicare's interests. So when is it worth it to go out to a company and hire them to help us prepare a life care plan or a Medicare set-aside? And I would say we're really, the only situation I would probably do that myself is in a catastrophic injury case. And would want to get the set aside. We would want to get agreement from opposing counsel, and we would want to attach that documentation to any settlement agreement. And in this recent seminar I went to, we had a very interesting speaker get up and talk about life care plans and Medicare set-asides. And her company has studied thousands of these, and the takeaway from their study of thousands of these plans is that they, in almost every instance, are a gross overestimation of what the future medical expenses are actually going to be. This company actually tracked the actual expenses following settlement, and they usually found that the set-aside or the life care plan overstated the amount of the expenses, probably by a factor of at least 10 in many situations. So you know, that's something I think to be aware of as we are establishing these set-asides, to be aware of that fact. Another way of protecting Medicare's interests is to do a structured settlement, or to set up an annuity, or to have other documentation showing that the parties have looked at the future expenses, they've accounted for them, and the settlement agreement sets out how that should be done. So in one way or another, Medicare's interests, you know, need to be accounted for and protected. Next slide. There are some situations where the future medical expenses can actually be reduced by operation of law, and that should be taken into account, because the future medical expenses may be $1 million, but our responsibility for that $1 million may be reduced by the fact that there may be policy limits, there may be comparative negligence that has been established, there may be statutory damage caps in your particular state, and there may have been some some apportionment either by a judge or a jury. So we should be aware of those things and take them into account with respect to the future medical expenses. Next slide. We already mentioned this earlier, getting counsel educated to use the portal or to the other Medicare options so that they can work with us, hopefully, in finding out what those past medical expenses are. And lastly, you know, our goal at the end of the day is to get a final satisfaction letter, or what's called a file closure letter from CMS stating that the lien has been satisfied. And hopefully, if we've taken the steps we've talked about today, that's going to be possible. All right, I'm going to ask Jason at this point to unmute people, and please identify yourself, and we'll be happy to entertain some questions for a few minutes here.
Thank you very much, Kevin. And as he mentioned, I'll unmute lines right now. What I would ask is that that you all check and make sure that when we go to unmute, that you do mute your lines while someone else is addressing a question to avoid any feedback. Okay, all lines should be unmuted. And Roger Sleet, if you're on the line still, I know you submitted a question via the chat. If you'd like to address question to Kevin right now, we'd be happy to answer it.
Good
morning, Kevin.
Morning.
Thanks for your fine presentation, as always. We had a unique circumstance that's come up in 2 or 3 cases, actually nursing home cases, where the company was being proactive about the Medicare lien and had submitted a report to CMS Medicare indicating a particular date of injury or date of loss that was different than the one ultimately submitted by claimant or plaintiff's counsel. The case gets resolved, and then after the fact, there's competing claims, and Medicare is saying, well, this one's been resolved, this one hasn't, and it was just because of the date of injury or date of claim. Is there any way to get in front of that you're aware of?
Yeah, and let me respond. We've got some people who are mute because we're getting background noise. But yeah, Roger, that's a unique situation that I don't think I've dealt with. Do you have cooperation from plaintiff's counsel in communicating with CMS through the portal? Has that option been tried?
Again, this is more.
He has to keep Jeff Gray.
Can you hear me, Kevin? I'm not sure if I'm muted or not.
Yes, I can hear you.
Okay.
His good work.
This is all arisen after the fact, so it's not as if it was a coordinated effort early on, which probably would have avoided the differing dates. But it's when you're dealing with, like in the correctional health care situation, a span of treatment, a course of treatment, and is it when it started? Is it the date of the incident? Is it the end of continuing care involved in these situations? So we have not had cooperation through the portal. We typically had threats after the fact from claimant's counsel saying, this is a problem we're making, fix it. And typically that can be done because the company has access to the claim that they submitted or the report that they submitted, and they just coordinate the date at that point. But it's just created a couple of hiccups on a couple of matters after the fact.
Yeah. I do not have a lot of help for you there, Roger. I have not seen that situation. It's pretty rare that the parties involved not at least agreeing to the date of incident, and then the issue really becomes, is this medical care related to that incident? And so anyway, sorry, can't be more help on that one.
No worries. Thank you.
Other questions? Steve, I don't know if you, having listened to all this, if you have any comments from the group or questions or instructions for us.
No, this has been very, very beneficial and very informative. Kevin, and your knowledge about Medicare and so forth came through again very clearly. These slides that you've done that you'll be sending to all of us, the forms that we sent out yesterday, we should all keep that. We've got the easy part. All we have to do is just bring you in. You're the one that has the knowledge, so that's what we've got to do on our end. Don't wait till mediation. Just early on in the case, as soon as we learn that there might be some issues here, bring Kevin in and let's tap into his expertise. But thank you for that. Let me make a comment to all of our attorneys today, just before I close here. But I want to thank all of you again for being here, but I also especially want to thank you for what you do for Horizon and for our employees, especially our healthcare workers. They have very, very difficult jobs. I mean, their lives could be in danger out there. We've had employees attacked by inmates. Here I'm back at the corporate office and I'm safe. I don't have to worry about that. But they do, every day, and they're there. And I sent you folks an email just the other day that one of our healthcare workers in Philadelphia died from COVID-19. So now they have that risk to deal with. And on top of all that, they get sued for medical malpractice. And 90% of the time we close our cases without paying anything. But being sued is very, very stressful. And they've got enough stress already. And then here comes a lawsuit, and that adds more stress to them. And this is where it comes in for me to thank every single one of you. You're there for them. And I truly appreciate that. My job is, I have a lot of different duties, but one of my jobs is to look out for you folks as our attorneys. And I work at that to look after you folks as well, just like you look out for our employees out there in the field. But thank you for everything that you do. But that's all I have, but I'll turn it back to Kevin. But thank you again for being here with us today.
Yeah. So, Steve, one question just came in about how do you make sure you get information from Medicare Advantage plans? It says plaintiff and plaintiff's attorney usually have minimal, if any, knowledge about the difference. All you can do is get a copy of their insurance card and get hopefully copies of the medical bills themselves. You can see who the payer is, and then you've just got to do a letter. You've got to do a letter to the Medicare Advantage plan telling them we've got a lawsuit going on. We need to know the medical expenses. If you're not getting a cooperation, that's really the way to go. I mean, the Medicare Advantage plan is going to want to tell you typically what their bills are so that they can resolve it with you. So anyways, hopefully that. All right. Well, Jason, we've gone a little over the hour, so why don't we close up? And I just want to thank everyone. I hope you're all well, and we all get through this pandemic together, and hopefully someday down the road get to meet again. Thanks a lot.
Kevin, thank you very much. We appreciate you staying on top of these complex issues, and thanks for your insights today. Steve, thank you very much to you and Corizon for hosting today's webcast. And for all of you that participated today, thanks again for joining us. We will work with Steve to ensure that you get a link to the recording of today's webcast along with Kevin's slide presentation. Typically, the recording of our webcast becomes available within 12 hours. So we will intend to circulate that tomorrow. So with that, thanks again to all of you, and have a great rest of your week.